All rise. The Court of Appeals for the State of Kansas is now in session. The Honorable Judge Stephen P. Hill presiding.
Please be seated. Good afternoon, everyone. This is the afternoon session of the Kansas Court of Appeals. My name is Stephen Hill. I'm the presiding judge in this afternoon's panel. Joining me is our newest judge, Angela Coble, and one of our senior judges, Pat McInerney, to my left. We have one case this afternoon, City of Escritch versus John F. Mcgovern II and others. Counsel, we have read your briefs. We have received a research memorandum from our research staff. Concerns your case, we've read that as well. We have just 30 minutes established for this oral argument. That's 15 minutes per side. So that's not very long. So I suggest that you get right after it if you want to make your points to us. Don't be surprised if we don't have a few questions, because sometimes we do ask questions because we need to understand what's going on. With that in mind, we'll start with the appellant. Counsel, if you'd enter your appearance.
Your Honor, Kevin Groberger on behalf of the appellant.
And are you going to rebuttal time?
Yes, sir. I'd like to reserve 5 minutes.
5 minutes. And for the appellee?
Luckman appearing on behalf of the City of Escritch, Your Honor.
Thank you. Mr. Groberger?
Just one question, counsel, before we get started.
Absolutely.
Any relation to Gal Grauberger? He's practicing in Wyandotte County.
I am not. I've been asked that a few times, and there can't be that many Groberger clans around, but
Apparently
they're apparently from different ones. So, may it please the court. Your Honors, I know you've read the briefs, and I'll try to avoid getting into too much of the facts and move on here, but I do briefly want to let you know exactly how we got here where we are. This case involves a boat dock and a sidewalk that were constructed by my client along the shores of Lake Wabunsie, which is a Corps of Engineer lake that about just a few feet of the lake along the shoreline owned by the City of Escritch, and then the surrounding or most of the surrounding property is owned by individual landowners.
Where did the district court get it wrong?
Your Honor, I think we've raised 3 issues that I think the district court got it wrong. We moved for summary judgment, as well as opposed the city's summary judgment motion on the initial issue of the city's their complaints and their common law trespass claim is based exclusively on alleged violations of the city code. The City of Escritch has a city code that deals with these types of structures. They have a definition of offending structures, ones that aren't approved prior to being built, ones that are built too large, ones that are built with the wrong material. Included in that city code, they have an enforcement mechanism that requires a notice to go out to the landowner that he has an offending structure, he has an opportunity to cure or request a hearing.
So your argument is the city, to seek enforcement, should have used the avenue of their own code for an enforcement procedure instead of the common law offense of trespass.
To a large degree, Your Honor, and that's based on the fact that the alleged trespass is based on the violations of the city code. We're not alleging that the city cannot pursue a trespass claim. We recognize that the city as a landowner has the same right as anyone else. But when the alleged trespass is you violated the city code, our position is you should have followed the enforcement mechanism in the city code.
Was the dock and sidewalk located on the city's property?
The sidewalk is on the city's property. The dock itself, it's a little bit different. The dock attaches. This dock actually floats on Water's owned and controlled by the Corps of Engineers, but it does attach. It is attached to the land of the city.
But if you take the attachment away, the dock floats off.
Exactly.
Wouldn't be much good for you.
Right.
What, I don't get too far into the weeds on this, but what's the Corps' ownership? Is it some like the mean high water mark or something like that, or is it there an actual identifiable line where the city's property ends and the Corps' property begins?
Your Honor, I'll do my best. That might be better for the city, but my understanding is that the city actually owns the land underneath the lake, as well as a few feet off of the shoreline. And it's a pretty well-defined shoreline by rocks. And then the city, or the Corps, actually has the water that's in the lake.
The Corps, like most Corps facilities, they control the level of the lake and
Correct.
everything connected with the water.
Correct. So that was one of our issues, Your Honor, and I'm going to kind of try to quickly move through the second issue as well, is that even if the city were trying to enforce, properly enforcing the code through the common law trespass action, we have an issue of the fact that we believe we had a license to build and to construct those. The third error that we have identified deals with damages, and I think that our first two issues are fairly well laid out in the briefs. I certainly entertain any questions about those, and I'll go back to those if I can. But I wanted to make sure I addressed a few issues on the damages issue, because I think that's an area where oral argument might benefit more. Again, remember, this was a granting of summary judgment in the favor of the plaintiff, both as to liability and to damages. And the damage provision, the remedy that the district court gave was a mandatory injunction requiring the full removal of the dock and the sidewalk. Typically in Kansas, the starting point for damages on a trespass is monetary damages. Certainly we understand and we acknowledge that if the courts have held, if there's an ongoing trespass or a trespass that can't be properly remedied, that an injunction might be the appropriate remedy. So we don't contest that the city couldn't seek that, but rather that the district court erred in granting summary judgment on that issue. Mandatory injunctions are extraordinary relief, and the party seeking it has to show that they're clearly entitled to that relief. And to do that, the courts typically look at that four-part, balancing test, balancing of the equities test, where they compare the different, harms to the different parties and the public interest, and decide whether a mandatory injunction is appropriate or not. There is an exception to that when it comes to a trespass claim that was set out in the Mid-America Pipeline versus Wethorn case, and I'm going to call that the Wethorn exception just for purposes of today. But the city has maintained that Wethorn exception applies, and therefore the court didn't need to go into that balancing act and didn't need to decide if the equities favored full removal of these structures or not. However, if a closer look at the Wethorn case, the ultimate holding was that if a party has clearly established rights in the property, then the court doesn't have to do the balancing of the equities and can move on and just order an injunction. However, the doctrine of that case is based upon the fact that and I'm going to quote from the case briefly, that the benefit of the doctrine of the balancing of equities is reserved for the innocent defendant who proceeds without knowledge or warning that they're infringing on the rights of the others. And that was the facts in the Wethorn case. The trespassing party full well knew they were trespassing, and they just went ahead and did it anyway.
Is that similar to the facts in this case?
It's not, Your Honor, because in this case, the trustee submitted an application to the city, asked for approval of all of these structures. It was brought up at a city council meeting. They instructed him that they needed to get approval from the Corps of Engineers before they could move forward on it. He went out, got that approval from the Corps of Engineers, took that letter into the clerk of the court, or I'm sorry, to the city clerk, not the clerk of court, took that into the city clerk, who at that point looked at the letter and informed him, you're free to build. So he proceeded at that point. It was after it was constructed, the city came back and said, hey, the city council never actually approved that. And therefore you need to tear everything out. So we think that's why the Wethorn exception is not applicable in this case, Your Honor. And in fact, there's a lot of Kansas cases since Wethorn that have looked at it and said, you know, when a party, it's an intentional act to commit a trespass. We admit he intentionally built the structures, but he didn't knowingly trespass on the other people's property. And in those situations, that's where the balancing of the equities should have been applied. And in this case, Your Honor, there were no facts in front of the district court to even have made that type of analysis. The district court simply moved from, I find liability, and therefore you have to remove the structures. We contested the fact that that was an appropriate remedy at the district court level. And we think we should have been allowed to present evidence that the equities might have required a different type of remedy.
Was it argued to the district court that coming into compliance with the city's requirement would be a remedy for this situation? In other words, take whatever steps needed to be done to improve the sidewalk, to improve the dock, to come into compliance, to get the permit that was needed?
Your Honor, those arguments weren't presented to the district court because that issue was never ripe for decision in front of the district court. The summary judgment motion, we opposed the plaintiff's summary judgment motion, claiming that we needed to be able to present that evidence and have those arguments. There was no evidence one way or the other.
So what are you asking us to do?
So, Your Honor, with regard to the issue of the enforcement of the city code, we believe that we were entitled to summary judgment, and we would ask that you reverse the district court on that, or in turn overrule the district court's summary judgment. With regard to damages, Your Honor, we believe that there remain factual issues that need to be resolved as to what the appropriate remedy is, and we've asked that the court remand this back to the district court for further review
Or further proceedings concerning
damages. And again, Your Honor, I'm certainly not conceding liability by jumping to this part in my brief, but I did think that was hopefully oral arguments may make that more clear what it is we're seeking and why we think it's appropriate.
You've got about 1 minute left if you're reserving 5.
Okay.
You may have answered this, but let me see if I clarify, if you will. On this balancing of equities, the facts that you asserted about going to the city telling you to go to the Corps giving you the letter, back to the city, it's okay, off you go. Are those uncontroverted facts in the summary judgment motion?
They're not, Your Honor. And again, I think the procedural posture of how the case got to where it was somewhat prevented that or didn't call for that to be done. There was never any, we certainly could have proposed, submitted an affidavit or a deposition or something to prove that. Our position has been, Your Honor, that damages are an element of the plaintiff's case that they're required to prove. And certainly in response to a properly supported summary judgment motion, we have an obligation to come forward with affidavits or other citations to the record to refute any properly supported claims that the plaintiffs have made that could support a finding against us on that.
But you were seeking summary judgment as well, so wasn't it incumbent upon you to present whatever facts via affidavit that you had that would support your position?
Your Honor, we were only seeking summary judgment on the limited issue of liability based upon the city's failure to adhere to the city code.
Why didn't you seek a summary judgment on damages?
Your Honor, we believed it was a question of fact that would not be, it's balancing, is it more harm to this party or is it more harm to this party? We don't believe that that's appropriate, generally speaking, on a summary judgment basis, and that it requires, a court to make fact findings that would be controverted if we had done so.
is balancing of equities, is that a jury issue or is that for the court? We think of applying equitable principles as a court function, not so much a jury function.
I agree, Your Honor, and I do think it would be an issue for the judge to decide, but it would be an issue, I believe, for the judge to decide as a fact finder, not as a matter of law, and certainly not on the record that was before him on that issue.
And of course, since we're doing this de novo, we're limited to just what's in the statement of uncontroverted facts and the arguments as to whether that creates a genuine issue of material fact.
Right, and I believe, Your Honor, that it is incumbent on the plaintiff to show that there are no uncontroverted facts and they are entitled, based on the facts in the record, that they're entitled to that extraordinary relief. And I don't believe there's any facts in the record that frankly weigh that one way or the other.
Counsel, you completed your time. You're getting into your rebuttal time. If you want to sum up, well, I'll give you that.
I'll reserve my time. Thank you.
Thank you.
Your Honor's ready.
You may proceed, Mr. Leckman.
Thank you, Your Honor. We'll start off with the first issue. I think that's the question about why the city did this way. And I understand the concern about the city code, and it is complex, and we do have questions that arise, but you have to go back to what we're trying to prove in this instance, which is a case of trespass. First issue is who owns it. Second of all, is somebody on the property?
Well, all of those things would have been proved if you had filed an action to enforce your code, correct?
No, the code.
When you have to prove that his client owned the property and put the sidewalk on there, you wouldn't have any of that burden? Why not?
No, the city code is like a nuisance code, Your Honor. It's our property. It's like they built something that they shouldn't have. It's dilapidated. We would tell them you've got a certain amount of time to clean it up.
But how
Fix it.
would you know who to tell it to?
Well, we
If
would have,
you'd have to allege that they were owned it, didn't you?
no, we have a permit, Your Honor. That's the thing. They would have asked us to build this thing and they would have applied for a permit, received it. We would have a permit in our office, and every year they would have paid us an amount of money that would have been their permit fee for that year to have the dock and the walkway. Structure and a dock on the lake costs them a certain amount of money. Now, at a certain point, maybe they don't, and that was an example that I would use, Your Honor, is how does the city code come into this? It comes into it when somebody has that permit first. They're there lawfully, right? Because that's the question in the trespass. Not only was the person there, they're there without right or authority or permission to be there.
What was the goal of the city's lawsuit?
The goal of the city's lawsuit was to enforce its property ownership interest in that. And
Was it to get rid of the sidewalk and to get rid of the dock?
yes, and have the defendant do that, not city taxpayers, to fund the removal of structures that were never permitted in the first place. The example seems kind of silly, but if somebody came and built a house in a city park, the city should not be taxed with paying for its removal. The people who did it should pay for that. And that's what the end result we were seeking was, a restoration to where the status was before then, when we had full property rights and it was not damaged by the fact that these things existed. Now, the city code sections are good when we have a name and a permit, they paid it, and then suddenly maybe their dock isn't constructed very well and its pieces are flying off of it. People and neighbors are complaining. Property values are going down. So they say, do something about this, city. And we would say, okay, we know you. Here's our letter to you saying this is what the problem is. Here's some pictures of it. Fix it, or you're in trouble. And then we'll remove it if you don't.
So your object all along for the city was to remove it. Had nothing to do to come into compliance with the city code.
And that's the pleadings in the petition were a reflection of the fact that I think a court on a neutral basis would look at Lake Wabunsee, see hundreds of docks all over the lake, hundreds of walkways all over, and then look at this one and say, well, why is this guy in trouble? What did he do? And a lot of people have permission. And the example I would give would be, it's very much a license kind of issue, like a seat license in an auditorium. Say you've got a stadium or auditorium with about 16,333 fans in it. You're the police officers. You're supposed to enforce who's there and who's not supposed to be there, who's trespassing, who's not. Somebody comes up to you and says, there's a guy over there. He's not sitting down anywhere. He doesn't have any uniform on. He doesn't look like he's selling anything, like concessions or anything. I don't think he's supposed to be there. Now, the first thing you do as a police officer wouldn't be go up there, grab him by the collar and throw him out. You'd ask him a couple simple questions. Sir, could I see your ticket? You don't have a ticket? Well, sir, do you work here? Why are you here? Well, maybe he did sneak in. And at that point, you determine that he doesn't have the right to be there. But you have to make that determination first. And the reason that we talked about what exactly you had to do to be in compliance with the city code and to get a permit and to be able to build your dock and your walkway is that we had to establish in the first instance that we have a procedure that they didn't follow.
Counsel, I'm going to tell you right now, a fair reading of your motion for summary judgment for the district court reads that we want this code complied with. And now you're telling me we don't care about code compliance. We just wanted to get rid of it.
Well, Your Honor, if it was.
And you've got a court here who has to make a decision about it. And obviously you won at the district court level and making this man take it out. Now he's going to have to reapply and then put back in the same, or you want to say that you're never going to give him a permit again because he trespassed?
Your Honor, that's in the discretion of the city in granting his permits. That's not in this court to direct or anybody else. And I can't sit here and say today what the city council is going to do if ever, this comes up again. I'm going to tell you that
it certainly was within the district court's discretion what judgment to grant you.
And based upon its conclusion that there was a trespass, I think certain things followed from that. And that's, I think, the issue that we're having a little trouble with here is that the city should not be, is the city tasked with allowing anybody who wants to come onto their property, do these kind of things, and then it has to follow some Queensberry rules to get them off? Or can they just say, we own this property, we want you off? Any other landowner in the state can go in and say, you can't be on my property, you get off. And we said that. We said, and we're trying to be fair here. We're not sitting here saying we have no reason. We're being out of whack here. We're saying your dock was too big. We don't let people build giant cement structures that cover the whole face of the shoreline. That's never been allowed. So when you build something like that without our permit, then you assume the danger, that the fact that we would say no to that. There is no compliance methodology whereby where that sidewalk gets approved by the city and is consistent with the city's code and its past practice. I'm telling you, right, that doesn't happen. Because
is it an uncontroverted fact that both the sidewalk and the dock are on city property? I think it's pretty clear about the sidewalk, but how about the dock?
Yes, I think that was an uncontroverted fact in the case. The dock,
right. And
I mean, I understand that there's a little bit of nuance here because, and I'm not going to agree because these facts were not developed, but the Corps doesn't, I don't think they own it. I think they regulate shoreline.
We don't care if it's an uncontroverted fact, it's uncontroverted.
Yes.
Our purposes. Anyway.
We own the shoreline, we own the ground under it. They have to attach to our property to do this. So I guess, did I answer the court's question there in that?
Well, I'm still wrestling with what the court has to do. I understand what the city's position is. You're not going to allow this man to ever have a dock or a sidewalk ever, but that's the city's position. But is that something that the court should consider when determining damages in a trespass lawsuit? And that's the question that I'm wrangling with. And I understand you're having some difficulties because it's not from the point of view of the city. It's what the court has to do. You still got about 6.5 minutes.
Okay, thank you. And well, I still can't get past the fact that I disagree with you about there being an approval here. An approval that fits within what the city has traditionally done, where you have a wooden walkway that goes directly from the back of your premises to the dock, so you can access it in almost a direct line, could still be possible. Their dock is oversized, shrunk down. Yes, it could get approved, but you cannot build. And what they've done is, instead of having that walkway directly down, they have a cement area that covers the entire shoreline, almost the whole part of their, coincident with their property lines. So that isn't going to get approved, I don't think, unless there's a massive change. Now, they've submitted as-built permits. We refuse those because they were as-built, obviously because they didn't comply. And that's all we thought that we could do as far as compliance was concerned, Your Honor.
And that's in the facts.
Yes, that's in the uncontroverted facts, is that they submitted the permits, they were not approved. We talked a little bit about that, but I'm going to disagree about the fact that we ever said anything other than the fact that they were going to submit a letter from the Corps. There was no approval. There was no, if you get that, we're all good. That's not what the minutes show. So they have some fact work to do if you guys are going to rely on that. And I don't think you are, but we've got to get, I mean, those are disputed facts, but there is no dispute about the fact that they submitted the initial permits. They were not accepted. As-bills were submitted.
If
Those
we,
were denied.
if we think those disputed facts are significant enough, we could remand it for an evidentiary hearing, correct?
I think that is within the court's authority to do so. And, but I think you're going to be disappointed by the fact that there really isn't much there, in the sense that there is no real dispute about the fact that these things are not.
Well, it's not my point to be disappointed.
Yeah,
It's my point to issue ruling, counsel.
yes, I understand that, Your Honor. And I think when you get down to that question of a ruling, if they are trespassing, as we say, the question isn't how do we as a city, without taking taxpayer money and removing things that we didn't put in place, we didn't approve, we had no part in, and we told them in no uncertain terms after the as-built were done, those are not approved. You're not going to get it done. What are you going to do? And nothing. Those things still exist today.
So counsel, after the as-built permits were denied, if we were just functioning purely through the city code, what would have been the next step for either the city or Mr. Mcgovern?
Well, Mr. Mcgovern, I really don't know how he would have done anything other than removed the items, I
But
suppose.
he could have requested a hearing
I
before the city? Or could he have?
I don't see
denied
why
or-
he would have a right to a
No.
hearing on a discretionary permit, Your Honor. I think the only thing I could think of, if I was approaching it from the other side, is that I would have to seek court relief through mandamus to force the city to approve a permit through some method. And the opposite is what would the city do if they didn't do this, which would be, well, right, question is, can we say it's a non-conforming structure, give them the notice, if they don't reply in a timely manner, or if they do dispute it, we get to the end of it, we say, it's still not compliant. Well, they say, okay, and then we have to remove it, because that's ultimately what happens in nuisance claims like this. We have no authority to direct somebody to go out and remove it. We can say, you need to remove it, and if they don't.
You got about 2 minutes, counsel.
So, does that answer the Your Honor's question?
Okay.
Okay. I would take a little bit of time and talk about, I don't know, we haven't talked at all about the idea of the license or the lease rights, how that plays into this. I don't know if the court's going that route, that Mr. Mcgovern has a license of some kind. I think what we would come down to is the fact that the case law, Page and Smyer, do allow a court to create an equitable easement in certain circumstances. These are not those circumstances. And because, again, I point out the fact that if the court wants to do an equitable delineation of what happened here, remember that Mr. Mcgovern submitted permits. We have to assume that he understood he have to ask for permission to build it. He submitted those permits, so we knew. He built it in the absence of an approval. And then ultimately, the as-built were submitted and rejected. So the equitable position that Mr. Mcgovern is wanting, in my mind, to say that,
It's already been explored when he applied for the as-built
yeah,
permits.
and he cannot force us in equity by building it to put us in a dilemma where we have to either remove it ourselves and incur the expense and try to chase after him, or do what we're doing here, which is seek enforcement of our property rights. The last question is, of course, remedy, and I think we've covered a couple of those things, but I think from our perspective, again, this is about whether the city should have to expend funds, taxpayer funds, to remove these items. We don't think we have to, and I think the freeze case is instructive of this, because the clearly established rights are that we own the property. There is no dispute about that. So once you get to the certainty of the trespass and the certainty of the fact that they aren't permitted to be on there, then you don't have to establish all these equitable forms. Just like in freeze, they said, the gas line is below plow depth. It's 36 inches. It's below frost line. Nobody's ever going to hit that. There's no damage to us having a gas line over this farmer's property, because it's never going to be disturbed. And the court said, no, that's not the question. The question is that you're trespassing. As soon as you did that, we have the right to assess these remedies and these damages. With that, Your Honor, I'll take any other questions you have, but I appreciate the court's time.
All right. Thank you, Counsel. Mr. Grunberg, you've got 5 minutes.
Your Honor, I'll try to be as brief as I can. I wanted to address a couple of the issues that were raised with Mr. Luckman, and then responses. One of the first things I wanted to note, Your Honor, is the notion that the city code only comes into effect and it becomes the administrative enforcement once a permit is issued, Your Honor. We strongly disagree with that. And we've quoted on page 3 of our reply brief a portion of the city code. Section 201 defines, quote, unapproved structures, which is where the enforcement mechanism comes from, as in part, quote, a structure that is constructed or moved in and for which an applicable permit has not been issued. So I think the notion that the city code and the enforcement and all of that only applies to people that got the permits and then they know who to go out and apply, that's simply not the facts. The city code, I believe, is part of the record in this case. I just wanted to address briefly the issue, Your Honor, and we've recognized that this is somewhat of an equitable issue that could come up is, well, if this defendant gets by with going in and building something without permission, anybody else could come in, and how that kind of opens that up. I think to a large degree, Your Honor, that's exactly what the Wethorn exception on the balancing the equities is there to do. If it's remanded, Your Honor, and they're able to present facts and evidence and prove to the district court that our client willingly and knowingly violated their property rights and he knew he wasn't approved to do it, then I think the Wethorn exception applies and they don't have to go into a balancing of the equities. Again, we never got to the point of being able to present those facts and that evidence. And so I think, talking again about the freeze case, Your Honor, if I'm correct, and that's one of the cases, but I know several of those cases, Your Honor, where the court said, it doesn't matter. We've proven a trespass occurs. You've got to remove the property. Again, Your Honor, those are cases where the plaintiff was able to come in and show that the defendant full well knew when they put the pipeline in that they didn't have the authority to do that. I also there's been some discussions about the dock and the sidewalk, and I just want to clarify, some of that could be remedies. The dock's actually already been brought down to the proper size limit. We believe, we don't know that, but I think there are remedies that the district court could have applied less drastic than full and complete removal of the sidewalk and the dock. With regard to enforcement under the city code, Your Honor, again, the enforcement structure is pretty clear. Once it's determined this is an offending structure and we're ordered to remove it and have gone through the process that's set out in the code, there's a fine. I believe it's $25 a day, at least it was when this case started. And so there is an enforcement mechanism there, and the city elected not to go that route, and that's fine, but they can't enforce the city code through the common law tort. They kind of had to go one way or the other, and we don't believe it was proper for them to meld the two together. If there's any other questions.
Any questions?
Okay.
All right, counsel, thank you.
Thank you.
We'll consider the case submitted with those. Very interesting arguments, counsel. We appreciate your hard work on this case. We will issue a written decision in due course. And safe journey home.
Thank you.
We are adjourned.